Good morning, all. I would like to welcome you to the 13th meeting of the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities, including the THA in the 12th Parliament. This meeting is being broadcast live on our YouTube channel, ParlView. And this is the committee's first public hearing pursuant to our follow-up examination into the recommendations contained in the first report of the Committee on the Administration and Operations of the Land Settlement Agency in relation to squatter regularization, the 11th Parliament, 2015 to 2020. And today we are pleased to have before us officials of the Land Settlement Agency, the Ministry of Housing and Urban Development, and the Ministry of Agriculture, Land and Fisheries. At this stage, I would like to introduce the persons present here and my committee, the Joint Select Committee. I'd like to introduce myself. I'm the chair, Dr. Varmadiyal Singh, an independent senator. And at this stage, I would like members of the Land Settlement Committee to please, introduce yourselves.
Thank you kindly, Chairman. I'm Wayne Innes, Chairman of the Land Settlement Agency.
Good morning, all. I'm Hazar Hussain, CEO of the LASCSA.
Good morning, all. I'm Evelyn Scott, Manager Corporate Services at the LASCSA.
Hello to all. I'm Lorraine He, Corporate Secretary of the Land Settlement Agency.
Good morning, all. I am Shalag Roseman, Senior Attorney at the Land Settlement Agency.
I welcome you all. Thank you for being here. At this stage, I would like members of the Ministry of Housing and Urban Development to please introduce yourselves.
Good morning, Chairman and Committee. I am Claire Davidson Williams, Permanent Secretary, Ministry of Housing and Urban Development.
Thank you.
Good morning, all. I am Michael Bing, Head of the Economic Research and Planning Unit of the Ministry of Housing and Urban Development.
Welcome. Thank you for being present. At this stage, the officials of the Ministry of Agriculture, Land and Fisheries, could you introduce yourselves, please?
Hi, good morning, you all. I am Beneficiaries, Acting Commissioner of State Lands.
Good morning, all. I am Glenroy, Junior Law at the Commissioner of State Lands Office.
Good morning. My name is Rihanna Paglanlao, and I am the Legal Officer at the Commissioner of State Lands Office.
So, very good morning to all. At this stage, would my committee members please introduce yourselves?
Good morning. I'm Sorry, I'm not sure if we overlapped with Minister Morris Julie, and I'm Jayanti Lachmidial, member of the committee.
Good morning to all. Esmond Ford here, member of this committee.
Good morning, everyone. My name is Khadija Amin, member of the committee.
Okay, so that was Ms. Amin for those who were not able to hear because of the little technical glitch we had. Good. So the objectives of this inquiry really is three objectives we have. The objective is to determine whether the recommendation proposed by the Joint Select Committee that previously inquired into the operations of the LASCSA have been successfully implemented. 2, to examine the factors that are hindering the successful implementation of the proposed recommendations. And 3, to examine the plans and proposals aimed at further improving the effectiveness of the LASCSA in regularizing squatters. At this stage, I would like Mrs. Claire Davison Williams, the Permanent Secretary of the Ministry of Housing and Urban Development, to please give a brief opening statement.
Thank you, Chairman. The Ministry of Housing and Urban Development and its implementing agencies, including the Land Settlement Agency, are committed to improving the physical and socio-economic conditions of citizens through public sector housing initiatives, particularly those in the low to lower middle income groups, as articulated in our National Development Strategic Plan, Vision 2030. The Land Settlement Agency was established under Section 5.1 of the State Land Regularization Tenure Act, Chapter 5705, Act Number 25 of 1998. Under Section 5.4 of the Act, the agency is charged with the responsibility for administering and carrying out the provisions contained in the Act with respect to state lands in Trinidad. In delivering on its mandate, the LSA, under the remit of this ministry, conducts infrastructural development works within the designated areas, as well as provide title instruments to eligible occupants. In this regard, the LSA is able to bring much needed relief to the most vulnerable families in Trinidad. In addition to its mandate under the Act, the LSA's responsibility was expanded to include other programs and projects over the period 2017 to 2021. The LSA's overall performance has been good over the years, as it has been able to achieve tangible physical and social benefits to residents in the communities it serves through its various programs and initiatives. While the ministry and the LSA has provided written submissions for the scrutiny ahead of this sitting as requested by this Joint Select Committee, it is important to note that the ministry has continued to provide support to the LSA with respect to the implementation of measures given to give effect to the recommendations made at the last sitting of this committee. These include increased fund allocation by approximately 53% over the period 2018 to 2022 under the ministry's consolidated fund to facilitate surveying of squatter sites, regularization and regeneration of squatter communities and other designated areas, the government-aided self-help housing program, the Housing and Village Improvement Program, the development of residential lots for former Petrotrin workers. Funding is also provided under the ministry's Urban Upgrading and Revitalization Program, which is supported by an IDB loan agreement. This allows for financing to improve the living conditions of residents in informal settlements. The ministry's legal unit assisted with the review of recommendations for amendment to state land legislation and also provided support for the drafting of a tenancy agreement policy, which was approved by the Cabinet in February of 2020. In terms of facilitating interagency collaboration, an interministerial committee was established in August of 2020 to aid in planning as well as expediting effective and efficient process of state lands development. The committee included members from agencies that process regulatory and statutory approvals, such as the Commission of State Lands, the Town and Country Planning Division, WASA, TNTEC, and other relevant regional corporations. While there may be more areas still requiring more effective and efficient management, the ministry will continue to support the work of the LSA and will provide the much needed support for the efforts in order to bring needed relief to the landless. Therefore, Chairman, the team from the Ministry of Housing and Urban Development is here with you today to assist with any further recommendations that may emanate from this August company and the sitting here today. Thank you.
Thank you, Ms. Claire Davison-Williams. I see you have elaborated a humanitarian duty that has to be done and the expanded rules that is necessary in giving homes on land to petrol workers and new duties that are under the purview. So I guess today we would have to go through if we are in any need to improve any such of the disbursement of these homes and where the shortcomings. At this stage, I'd like Mr. Wayne Innes, Chairman of the Land Settlement Agency, to give some opening statements, please. We are not here, and I think you are muted, sir.
Are you hearing me now?
Yes, here now, thanks. Loud and clear.
Yes, again, thank you kindly, Chairman. And again, morning to members of your team and to the members from the Ministry of Housing and Urban Development and the Ministry of Agriculture, and of course, members of the LSC. I thought that the presentation on policy made by the distinguished Permanent Secretary from the Ministry of Housing captured, in terms of policy, everything that is happening at the LSA. On operational issues, I will ask the CEO, Mr. Hazar Hussain, to make a presentation on operational issues to the team. But in terms of the policy, most of it has already been captured by the distinguished Permanent Secretary. Thank you.
Yeah, so thank you, Mr. Ennis. We would now like to go to Ms. Banmati Sitran, the Commissioner of State Lands, to give some brief opening remarks.
Hi, good morning, everyone. In terms of this Joint Select Committee, the Commissioner of State Lands under Chapter 5701 is charged with the protection of state lands and the management of state lands. And under Section 20, we are charged with dealing with squatting. Together with the LSA, we have been doing work, collaborating, taking a stance on squatting. We also deal with the government assisted self-help program and the land for the landless programs. Additionally, any other matter that LSA needs, we would assist. We have basically been getting information from the LSA that comes to us, and we literally work with them hand in hand on an as-need basis to manage these matters. Thank you.
Thank you. And Mr. Wayne Innes, we would definitely entertain your further comments from your CEO, but as part of the questioning, we would now, we would direct questions to him, or he may be able to clarify certain things. So at this stage, I would like to remind both committee members and officials to direct your questions to the chair. And I would like to remind members and officials to kindly activate the microphone on your devices when you are acknowledged by the chair, and turn it off when you have concluded your contribution. And so at this stage, I would like to say that we are here this morning to see if the mandate or the recommendations in the last Joint Select Committee, if somehow we are falling short, and if we are falling short, how we can somehow get these, any sort of additional benefits or any sort of additional recommendations we can put into place. It seems that when the last Joint Select Committee met and the recommendations were given, we thought we had some answers and we'd get further through. But I must say, subsequent to that, we have had instances in the newspapers where I have seen, persons saying there's a concern over land grabbing in Sandy Grande, Point Fortin. There are other instances where squatters rush to build lands on Tupu Port. So all of these instances, we have to look at, are we somehow falling short, and what do we need to do? So these are newspapers reports, and there were actually comments from certain persons who, try to give recommendations. So I guess we will go into that further on. But really speaking, to deal with the squatting, I think, issue in Trinidad and Tobago, it's an issue it's global, it's worldwide. And the Land Settlement Agency came about as a humanitarian effort to help those to have some sort of social ease. Those people that were already squatting for quite a few years, they were given the function to try to regularize those squatters. We have to know now that, persons may have different reasons why they squat. And while we look at the humanitarian reasons, while we look at the individuals who have been long-standing inequities in society, others who, due to unemployment and present economic climate, some persons have been pushed in the poverty bracket. And some people persons with a pregnant wife out of work, evicted due to a failure to pay rent, may see no option. Without the basic right of a shelter, they build on state lands to escape living on the streets. Many squatters are homeless and vulnerable due to no fault of theirs. And others, however, may be land grabbers trying to get a piece of the action. So therefore, we have to discern how you all are doing that function, and to look at the humanitarian aspect, as well as try to prevent any sort of runaway land grabbing. So the rapid increase in squatting reported in the press took place during the pandemic, and it may be a reflection of increasing poverty, the shrinking middle class. It's like a rumbling social volcano. And last year, as reports came, it may have to be described as a year of the squatter. And some persons, I say, may not be able to pay rent. They may go, and we had the traditional rural-urban migration. And while government has been working to ensure that every citizen can own land through lawful means and through land titling and regularization projects, it appears that we have been lagging behind demand. In fact, squatting is the most highly visible manifestation of acute housing shortage. It serves as an indicator of the government's challenge to provide to its citizens inexpensive housing. So it's a clear indication of the need for social housing, which includes housing for the indigent, as well as subsidized rent or shared equity to compensate for limited consumer affordability. So all of us will play a part in somehow trying to get the humanitarian aspect taken care of, trying to ensure that we deal with those individuals who are impoverished, but we also have a duty to the citizens not to have any runaway squatting occur and people taking advantage of the situation, and even squatting in areas where forestry will be affected, the environment will be affected, and even crime. So certain areas you have, even like in Valencia, have been seen now increase in crime, upsurge in crime. So we'll have to look at that interplay, how we can manage these issues with squatting and the ill effects of it also. So at this stage, I would like to start the questioning to the Land and Settlement Agency members present here. Do you think that the squatting the squatting population has increased during the pandemic, as reported in the press. You know, and I'm trying to get this because I'm thinking, you know, if during the pandemic people were under lockdown, how were they able to, you know, go and squat and move around? So do you have any figures about the proliferation in the country? Has it increased recently?
Chairman, good morning. Good morning to the members. Hazar Hussein, CEO of LASCSA. The best way to deal with this is to actually look at statistics that we have. And if we look at the years, I'll start by looking at the years after the last sitting that we attended. And between the years 2018 until April 2022, the number of reported cases of squatting, new cases of squatting that we have picked up is just under 1,200 cases. During the years of the pandemic, since then we've had 2020, 74 cases, 2021, 293 cases, and for 2022 so far until April, 157 cases. But if we compare this to the years prior to our last attendance here, the 5 years prior to that, between 2013 and 2017, in fact, we had over 5,000 reported cases of new squatting. So there has been a significant reduction in the number of reported cases of new squatting between prior 5 years and the present 4 years that we're within now. So there has been, and I think what has accounted for that is the work that has been put in by the Commissioner of State Lands and the Land Settlement Agency, coming out of some of the recommendations from the last appearance. We've had the setup of, well, of course, the LSA has its own containment unit where we continue to monitor what is happening on the ground. What we've used is a community-based approach where we are going into settlements, having regular meetings and letting persons know about the ill effects of squatting. And I think that has created some sort of deterrence. The Commissioner of State Lands Office itself has set up an enforcement unit. I think that was done in around 2017. And together with that, we now have an interagency task force that has been established, which involves the police service, which has also been helping to monitor squatting. So we have had significant reduction in the numbers. We have also been using a lot more of technology since our last sitting. We've been using GPS information, mapping every structure that we find, so we're able to tell where we have new structures so we can monitor better. We have been using a lot of drone technology. And of course, satellite imagery that is available to us, so we can compare data from one period to another to see changes, and we can react much faster now using the technology that is available. So there has been significant improvement, Chairman.
Because what I got from the newspaper report, squatters rushed to build lands for Tobago port. It was, I think, there were comments made where I think it made mention that the illegal occupancies by fresh squatters have been given the chairman of the Sandy Grande Regional Corporation. I think it is Mr. Roden is the chairman. Yeah. Terry Roden, no end of worry, as he called on the government to do something fast, stating the issue of squatting was totally out of control. He also, in this release, made mention that a lot of squatters are in direct pathway of the 400 million Kumutu Manzanilla highway project. And he also said that, so we have to appreciate, he was at pains to go to those squatters and tell them, look, this is government's plan, you are now in the way there. So I'm wondering, in a sense, there are certain squatters who may have gone into areas to protest, they may not want a highway. Some areas, people may go because they may think that if they go there, they will not be paid to move. There may be different reasons. But Ronden said that some squatters have been masquerading as farmers by cultivating short-term crops, hoping the state would not zero in on them. He also said Venezuelan migrants have already cut down several coconut and walnut trees on forest reserved. And so we are here in this discussion, we are seeing upstanding member of the Sandy Grande Corporation actually complaining, actually trying to reach out for help. And he describes it as a wild, wild west situation. So, yeah, so is it that, how do we come to terms with what was said publicly by this esteemed gentleman? How do we come to terms? Is it that you have your containment unit being not staffed properly or not going out to discover these persons? Is it because we're getting a disparity here with what's being said in the press, as well as the fact that you're saying that there's a reduction, and so somehow we have to try to figure what's happening. If you have any comments to give us an idea about this.
Sure, Chairman. And you're right. So yes, as I've shown, the numbers has gone down, but there are certain hotspot areas in the country where we have a rush of persons going into squat. And as reported in the newspaper, areas in Sandy Grande, the Valencia stretch, where the area where the new highway is proposed are areas that has been a challenge to the Commissioner of State Lands and the LSA, where we have new squatting. We have a term that we use, squat lords, where a lot of these persons who are rushing in these areas are rushing for commercial reasons rather than for economic reasons, and that's a problem we do face. But there are certain hotspot areas where you have an increased number of squatters, and those are the areas of concern for us. And as we pointed out before, Valencia, the areas in Sandy Grande, the Mabande area, the Nouveau Park, which is dubbed Nouveau Park, a new area where the new highway is proposed to pass. Those are the areas that are challenging to us. But overall, the numbers has gone down overall in the country. You also mentioned Tobago, but the LSA has no responsibility with respect to what happens in Tobago. So I just want to make that point.
So therefore, definitely there's been like a squatter invasion in certain areas, like Sandy Grande seems to be the squatting capitals, and also Valencia. And I made mention before about crime in some of those squatting developments, which is a social issue. We may have to see how we could contain it if it's going to be causing some problems. So the humanitarian aspect is there, as well as you mentioned, building in the direct route could impede government's plan to develop the country. And we have to know, is it, as I say in protest action, is it persons are coming in to try to get a piece of the pie if you have to be paid to move out or, cause a problem? There were protest persons, in different countries where they may not like something, so they would go and squat on a site and protest. But in a sense, look at the Valencia area. Do you see, do you have any ideas about complaints about the increase in crime in that area? That may be more something for the police commissioner, but I mean, your members going in there, are they in need of police protection to go into certain areas for fear of certain criminal elements may chase them out?
Again, Chairman, I mean, that's really a matter for the police, but based on the newspaper reports that we have seen, there's some sort of correlation between what takes place in squatting areas and crime, based on reports that we have seen in the newspaper. And of course, we think there's a need for intervention, and that's why the LSA is not only about developing squatting sites, but it's all about sustainable development and community improvement, where we go into these settlements and we engage communities, we hold their hand, we conduct training, we set up community councils, we have a micro enterprise unit which we have involved in these areas, and that's all part of the improvement of these squatting settlements at the end of the day. So this is the approach we have been taking to improve the lives of persons in these areas. But if I just go back to your point on Valencia and the highway, again, I reiterate that we do think that there's a lot of people speculating. And when you hear things like highways are coming in certain areas, there are a lot of persons who speculate with the hope that they will be compensated at some point in time if they're in the way of the proposed highway. So this is an issue. But we have been gathering information and submitting all that information to the Commissioner of State Lands Office and to the different regional corporations, including the Sandy Landing Regional Corporation, for they to take the necessary action in accordance with their law.
And so do you have an issue with like have you seen an increase as reported here in migrant squatting in certain areas?
There has been reports, Chairman. We have had no specific information to say that we have picked up migrants, let's say in our containment efforts and in our patrols that we're making. No, we have no specific data to that.
Chairman, may I just clarify one issue?
Sure.
The proliferation of squatting in the northeast of Trinidad, the LSA is responsible for containing or restricting squatting on listed or designated squatter sites. It is possible that where that proliferation is occurring on state lands and it's outside of the remit of the LSA, that would be better addressed to the Commissioner of State Lands. Just wanted to clarify that.
So you all have actually been given the mandate for certain squatting sites, right? So I think this is something the public needs to be aware of, because sometimes people may want to lay blame and say, hey, you all are not doing this and that. But remember, your mandate, when you came initially, I think it was in 1998, I think, the Act of Parliament. When it was it 1999? This Land Settlement Agency had a very humanitarian duty to help those individuals who were there with poor infrastructure, because remember, those developments were there, no sewer, no roads, etc. So I think it was a recognition then that we cannot leave part of our populace in these underdeveloped areas without basic amenities, sewer and running water. And I think the whole idea of the Land Settlement Agency was to help these individuals to have that duty to able to, they were there already. Sometimes they would have built up the area, they would have built up their houses to at least give them a better level of sanity, because remember, those sites could develop into disease manifested areas if they don't have certain amenities. So I think the agenda of your body, the Land Settlement Agency, was there to help those squatters, but also to contain, to prevent the other squatters from coming on board. And I guess the individuals, again, may have to in your department, may have to tell us any shortcomings or challenges in terms of your containment unit. And I guess we will also have to question the Ministry of Agriculture for the other side. So thank you for that clarification. I think member, I think Member Lochmidial had a question to direct to you.
Hi, good morning. Thank you, Chair. The Chair, through you, I want to ask the Land Settlement Agency. Well, firstly, I've noted in your submission, you spoke about a decrease in the number of reported cases of squatting, but you also indicated in your submission that there was also a reallocation of your human resources and also a cutback due to COVID in terms of patrols. Do you have a system, electronic or otherwise, where members of the public, apart from what you may detect, where members of the public can report squatting that's taking place, illegal squatting and new structures that are coming up in the areas that they live in? So that's the first question that I wanted to ask. In the last report as well, some of the recommendations, this is the first the report that was submitted previously by this committee in the 11th Parliament. One of the recommendations had to do with regular surveys. Could you update us on those surveys, how regularly they are taking place, whether or not they're being done annually? And finally, I think I would like to find out when you detected, in terms of the 112, I think 1,212 patrols, you indicated in your submission about the number of structures detected up to 2020. No, sorry, that's the patrols, 1,212. We want to know how many structures identified and what you did with respect to those structures being identified? And could you clarify for the public where in fact you conduct these patrols? Is it restricted to the areas that you have under your remits in terms of the lands identified by the Act, or is it generally that you would patrol areas for squatting, or whether or not those squatting on lands outside the remits of the Act falls to the Commissioner of State Lands?
Member, I'll start with the system for reporting illegal activities. We do have a system, a robust system established. We have where members of the public report cases directly to the LSA. We also have a hotline which has been established where persons calling to report new cases of squatting. That's 866-1111, and persons calling on a regular basis to report new cases of squatting. So that's well in place. With respect to surveying of squatting sites, coming out of the last recommendation of the committee recommended regular surveys to be conducted, and the LSA has been doing regular surveys. The last comprehensive social survey was done in the year 2019-2020, where our squatting sites as listed in the Act or designated sites were surveyed, or 251 sites were surveyed. That was done in 2020. As we speak, we continue to do surveys in LSA designated areas to update our information with respect to new squatting. You asked about the number of patrols and the corresponding number of squatters that we have discovered, new squatting. For the same period, 2018 to 2022, 1,170 new squatting structures were picked up, and in the areas that we patrol and that we required to patrol, and all of these were reported to the Commissioner of State Lands and to the respective regional corporations, so they can take the action. I just want to remind members and to the public that the LSA has no responsibility in law, has given no powers in law to contain squatting. It still remains with the Commissioner of State Lands. So we can only report on what we find out there. The last question, I think, was where we are restricted to. Of course, as Chairman Ennis pointed out, we are restricted to patrolling our designated areas. There are 251 designated areas listed in the Act 25 of 1998, and the LSA is restricted to those areas.
Okay, just a follow-up question, Chair. There's, in terms of certificates of comfort, no, sorry, well, let me get a follow-up question first with sorry, you mentioned about the hotline. The hotline reports, are they included in the new cases of squatting detected here, or the cases that you gave us is just what you picked up on your patrols, or is there a follow-up of a patrol when a hotline case was reported?
Yes, excellent question. Every hotline report is investigated because sometimes you do have hoax calls. So before we report a matter to the Commissioner of State Lands, we verify the information. We send the officers out there to investigate to see what is happening. And where there's a genuine case, that is recorded and reported to the Commissioner of State Lands. Okay. And finally, I don't know if this would be, if you would answer this, or the Commissioner of State Lands would be able to answer this, but I've noted particularly persons who claim that they have purchased property from people who have certificates of comfort. So from 1998, when the LSA came into effect, you would have issued certificates of comfort would have been issued to persons. I think at the last report of the 11th Parliament, there were a significant amount of applications outstanding. I think you all have made some headway, but if you could update us on that process, but also what is in place to detect, because what I see happening are persons of significant means purchasing and attorneys preparing what we call chattel deeds, and persons who have built structures now on lands which they occupy under a certificate of comfort, basically selling over the structure by way of a chattel deed to someone else who is now occupying large areas of land which would have been granted to various people for certificates of comfort. The certificate of comfort doesn't really give anybody an interest in the land. They prevent eviction, correct? So how it is that these things are happening, people are now occupying
lands which previously would have been given to people certificates of comfort? Are you following, are you monitoring this issue with deeds being done to sell the property, although they cannot sell the land, but the land itself now being occupied by persons, sometimes 3 and 4 and 5 lots in an area, somebody moving in and buying out all of the land from all of the squatters in a particular area and occupying the land? Is that something that you have detected, and that, you know, what are you all doing about it? And do you think that, sorry, just last thing, do you think that there's a need for more enforcement for all the LSA or some amendment to your to the law that governs you in order to deal with issues like that?
Okay, so there's a number of questions. I'll attempt to answer them. So let's start with the certificate of comfort statistics that we do have. We had just over 22,000 persons who applied for certificates of comfort. The application closed on the 27th of October in the year 2000. So that's something that the public needs to be aware of as well, because many persons are still under the belief that they can apply for a certificate of comfort. But just to reiterate that, that was closed on the 27th of October in the year 2000. And as at that date, we had just over 22,000 persons who applied for certificates of comfort. The good news, and coming out of the last session that we attended, we have now completed the majority of investigations. At this time, we have about 2,500 pending investigations, and they are pending for 2 more reasons. Title searches pending to determine the actual ownership of the property to ensure that's state land. We have 1,382 cases of title search pending. And then we have just over 1,200 investigations to complete. So we have completed the bulk of the investigations as far as applications are concerned. And we made significant progress from the last sitting that we attended. In terms of the number of persons who receive certificates of comfort, it's just over 8,000 persons. And our estimate, that number would not surpass around 10,000 persons receiving certificate of comfort from those who apply. So there are many reasons why persons will not receive a certificate of comfort, starting with persons who are on private lands who applied, and there are a number of persons on private lands who applied, for example, on private estates like Sagan Estate. There are many cases of lack of jurisdiction where persons have occupied lands that cannot be done for residential purpose. So we are unable to give a certificate of comfort on agricultural lands under the Commission of State Lands. And of course, there are persons, many persons who've died. In fact, there's just over 1,000 cases of persons who've died. And of course, the certificate of comfort is a personal thing, so it cannot be passed on to the next of kin. You mentioned sale of house. It is an issue. It is an issue, and we have more than 400 cases of persons who have sold their houses. But there is a provision for where a house is sold, for where persons can, the person who bought under a contractual arrangement can benefit. So there is a provision for that. But yes, there are many cases of people buying and selling property and buying up large chunks of property that we have reported to the Commission of State Land, buying property from several certificate of comfort persons. But in law, just to remind the public again, what you're entitled to, the first thing is the certificate of comfort. You move to statutory lease and a deed of lease, and the law says that you're not entitled to more than 5,000 square feet. It's 5,000 square feet, more or less. So during our investigations, for those persons who attempt to buy up large chunks of properties or buy out several persons who have certificate of comfort, when it comes to the next stage, you will not be processed.
Right, but okay, I just stick up in there. Through you, Chairman, you mentioned something, CEO, about there's a provision where persons who purchase the houses can benefit. But then you also mentioned that people who die, you can't process the application. So the issue there, and it's something that I have come across, is that, for example, someone who would have applied before 2020, well within the time for applying for the certificate of comfort, if they die, let's say the breadwinner of the family, the main person, the father, passes away, but his wife and children are still living there, they are now not entitled, they will be excluded. Whereas somebody who comes in now and purchases a certificate of comfort or purchases a house that is erected on land that was issued to someone who was given a certificate of comfort, who decides to move on and move along and migrate or whatever they wish to do, that person is actually entitled to occupy the house and is on the land. Whereas people who have actually been living there for a significant amount of time, just because the person who made the application, the head of the household, may have may have died or something like that. I mean, that seems patently unfair and a bit unjust.
And you know, one of the most significant change that has happened in the last couple of years is the decision by the cabinet in the year 2020 to approve what is called the tenancy program. And that has made a significant change to the for this group of persons that who you refer to, along with others. And the change here, as with respect to the law, the State Land Regulation Tenure Act, you had to be there before 1st of January 1998 and made an application before the 27th of October in the year 2000 to be entitled to a certificate of comfort. And as you rightly said, there are many persons who, because of several reasons, would not be processed and would not be entitled to move forward. But the significant change that took place with the passing of the tenancy program is that any person who is on a developed plot of land that has been surveyed and approved by the Director of Surveys, and you are there on state lands, surveyed and approved, prior to June 14, 2014, will be recognized and processed. So those persons, for instance, where the person has died, but the family is there, and once we can determine who is the legitimate person, when we come around to your settlement, those persons are entitled to move forward. So that's a window and an opportunity that these people have now, that they can move forward and be regularized. And under the tenancy program, persons are entitled to a short-term tenancy in the first instance of between 1 and 3 years, which is granted by the Commissioner of State Lands upon investigation by the LSA and advice of the LSA. They are then entitled to a statutory lease for 30 years and followed by a deed of lease for 199 years. So that has really addressed that issue that you raised.
Mm-hmm. Could you tell me, to date, do you have any idea how many people may have benefited from that program, that tenancy program that was introduced before, where you had to make the application for 2014?
Okay, so it's a new program that was approved in 2020. We are in the process of taking applications, and what we're doing it from site to site. And for, as I said, it's for the developed sites that has been surveyed and approved. So far, applications received is just under 400. But as we go from site to site, that number will go up, and as we educate the members of the public. For instance, we were in an area called Pine Settlement last week, where we went in there and we had over 100 persons attended that session. We intend to go to Springle Street very soon in Point Fortin, and Hamley Hall in Gasparilla is coming up. And we are approaching these sites in this week.
Right. Perhaps in writing, if you could give the committee a list of all of the sites identified, which have been surveyed and approved by the Director of Surveys, and where you plan to visit and how you plan to go about this program that you said was approved in 2020, that would be helpful.
Certainly, we'll provide that in writing.
Thank you.
Mr. Chairman.
Yes, Member Ford, you could.
Could I proceed?
Yes, Member Ford, you can proceed.
Thank you. Okay. Good day again to all. To LSA, the tenancy program, seeing that we just hit that particular topic. In the Tuna constituency, right, where we have a lot of the Badisagan Mirage property with the executor, Mr. Satmaraj, who would have died a couple of years ago. The tenancy program falls within this particular community, Mr. CEO of LSA. The residents.
Chairman, member, the LSA is restricted to dealing with state land. Private estates, private lands are not within the remit and the law that the LSA operates. So we cannot deal with those areas unless the state makes an attempt to purchase those property and then and only then, and if those areas are brought under the schedule of the Act, then and only then can the LSA deal with those estates.
You see, because again, through you, Mr. Chairman, this Badisagan Mirage property issue has been going on even before I born. You know what I mean? And we are talking about persons that have been residing on these properties, for over 70 years. And, you go LSA, one set of information. You go Commissioner of State Land, one set of information. And, no sort of direct approach to these individuals who cannot be removed from the particular property because of legislation. But somehow, are not able to get their tenancy recognized so that they can have a deed in their particular hands. And you know, I mean, I think it's the irony of the situation, you know, because as a member of parliament, you go asking for their votes, and at the end of the day, you know, they are not regularized in terms of their tenancy, but yet still, you know, we are unable to assist, you know, from the member of parliament office. But we leave that there for now. In terms of the responsibility for evicting squatters, who or what agency is responsible for that? I want a direct answer, please. Who, because you mentioned you have LSC has no powers in order to act, right? You can only report. Out of the panel we have there, through the Ministry of Housing and Urban Development, through the Commissioner of Statement, LSC, who or what department or agency is responsible for evicting squatters in Trinidad? Well, the state Tobago may be out of the remit for now. And then I'll
Chairman, member, I'll attempt to answer that last question. Clearly in law, the agencies that do have the power to evict squatters, we'll start with the Commissioner of State Lands, under Section 20 of the State Land Act, has the power to deal with new squatters and to evict squatters following a process. The regional corporations under the Municipal Corporation Act do have the power under Section 163, 164 to issue show cause notices for unauthorized structures. So, and they can take action within their law if someone is unable to prove why they've constructed an illegal structure. So those are the two agencies or institutions that has the direct power in law. And you're right, the LSC has no power in law. The State Land Regularization of Tenure Act clearly stated that the LSA does not have that power. The LSA is supposed to provide alternatives to squatting through providing land, etc. That's what we are supposed to do. That's our containment powers.
So my follow-up question, therefore, will be directed to the Commissioner of State Land, Ms. Sicharan Acton. Okay, why it is in instances where squatters have been identified, right, whether reported via the hotline through the LSA, whether by surveys, whether by mapping, whether I read where you all have the GIS system where you all can do the drone technology and so on. And we have been able to identify individuals who would have been squatting in areas, like for instance, with regards to, let's say, the Valencia-Toco highway situation now. If those persons have been identified of going into those areas within the last year, 2 years, 3 years, why are we not in a position to evict these persons? Madam Commissioner of State Lands.
Okay. Hello again. I will pass that question on to my legal officer.
Good morning, everyone. Again, my name is Rihanna Palunandla, and I will answer that question as best as I can. We have reports from the LSA regarding unauthorized occupants on their lands. We have had several challenges with respect to actually processing matters through the courts. So firstly, when we receive reports from the LSA, we have had instances where we've had structures demolished. So from January 2018 to April 2022, we've had 34 land clearing exercises that were conducted. From 2017 to April 2022, we've received reports of illegal squatting. 85% of those squatting matters that were referred to us, we cannot process through the courts because we have improper or inadequate identification information for those occupants. So that is one challenge that we've had to face. The second challenge really is confirming ownership of lands through title searches. The legal unit at the Commissioner of State Lands Office would have been here since November 2019. In that time, we've had challenges with accessing information through Registrar General and the GPO office due to the COVID-19 pandemic. That is important to file matters at the court. That is one of the pieces of evidence that we rely on. We have also served quick notices on plenty of those matters that would have been referred to us from the LSC. So that is the position of the Commissioner of State Lands Office with respect to the reports that were received from the LSC in terms of illegal squatting.
So, but again, through you, Chairman, to the Commissioner of State Land, the longer this process and period goes on, is, for want of a better word, is the worst scenario we are going to end up in Trinidad, because time will be going, individuals will continue to be at these sites, which supposed to be an illegal squatting site, and how again can the process be expedited? Because we are saying whether these individuals will hinder the continuance of the highway going forward, for whatever reasons, because I heard the LSA use the term person squatting for economic reasons, whether you call them squat lords, as the case may be, especially in the Toko area. I think, we need to ensure that, this situation is regularized as soon as possible, because the longer it goes on, it will become a serious red herring, in the progress of infrastructure development going through in the Toko area, especially for the individuals that have been identified as recent squatters, right? There may be the one that may be there for over 20 years, 15 years, but what about those who would have recently been identified? There would have to be some process where we can deal with these individuals. Any response, Madam Commissioner State Land?
Sure. In the first instance, the Toko area with the squatting, we did our title search on that area. The squatting in Toko is basically on private lands owned by Wharton Estate. That includes the area with the beach. At one point in time, the Ministry of Tourism did right to acquire the land, but that was never followed through. So the squatting in Toko literally is out of our hands because it's private lands. The squatting outside of those areas that are reported, literally, if we have to deal with squatting, there's a process. We serve you with a notice, and then we take you to court. In order for we to serve you with the notice, when we serve you with the notice, we give you 7 days to move. The problem we have is that these squatting areas, because people are aware that if the house was constructed and there are persons living in it, we cannot demolish the house. We would need to take you to court. You find out over the weekends, for example, if there was a long weekend, you leave today and you come back tomorrow and you will find a house with occupants in it. If there's occupants in the house, we cannot deal with it. Public servants, most of my staff are public servants working 8 to 4. We do go outside of the hours, but these persons actually know when, they know how, and they go on the spot. With that, we also have restricted human resource, machinery, assistance. For example, I have written to the Standing Grande Regional Corporation many times asking for assistance. We don't have a backhoe to go and demolish a house. But when we ask, they continuously say, no, they do not want to get into that. The persons in the area know that. So therefore, we are left with our hands tied. If we do not have the personnel and the machinery to demolish the house, by the time we get to it, it means that the house is constructed, it needs to go to court. 7 days, we still need to verify all our information, then take it to court. Again, by that time, a house is there, the persons are there, and then the courts tend to rule in favor of the persons.
Could there be a policy or some sort of system to avoid this situation of land grabbing and squatting? Do you all have a policy document or something where but I know manpower may be one of the major issues here, right? But I'm saying that measures employed to address the issue of land grabbing, have we listed 1 to 10, various measures along those lines between the Commissioner of State Land and the LSA to avoid situation like this? Thanks for your response.
Technically, the LSA, once they find, because they have a containment unit and they have security officers, they will come to us and ask for assistance. And once they come to us with their request for assistance, we provide that immediately. Our officers will go. We would demolish if it's not already occupied. Outside of that, there is no, because we have to pick it up and go through a process, there is no way of dealing with it.
All right, last question, Mr. Chairman. Last question on this particular aspect. Squatters that have been identified for regularization. Why is there a delay in regularizing them to ensure that they have some official documentation in their hand? Persons that have been identified in Trinidad. How many squatters do we have in Trinidad that have been identified for regularization? And what is the delay in ensuring that they can be processed and regularized? Definite answer, please.
Okay, so basically, persons to be regularized, we still need to go through a process. Most of the times, we have to go to cabinet for a decision. And to go to cabinet for a decision, we have to do the research, we get town and council, depending on what it is. If it's residential, no, but if it's agri or any other, we may need to go to EMA. And then the commission of valuations. All of that being access, we then take a note to cabinet. These long delays basically affect the granting and the renewal of leases, the transfer of land, acquisition, issuing of lease and licenses, and all of that. In these cases, after we do the whole process, it then goes to Chief State Solicitor. Therein lies our problem, because we rely on all these external agencies, or we literally have to wait. If we didn't have to rely on all these external agencies, leases could be granted in 2 months, 3 months, but given town and country, commission of valuations, chief state, and any other statutory authority, we literally sit and wait on these agencies.
Again, I understand your answer, but still, to the small man, quote unquote, which is the man on the ground, the individual who is squatting in a small shack, waiting for his regularization document, we cannot remove him, but then we would hear of instances of other individuals who may have gotten through the system, and for some reason, theirs approved, but the other man not being approved. No need to comment. Thanks, Mr. Chairman.
Yeah, so thank you. At this stage, I'd like to find out from the legal officer, when you mentioned 85% of cases could not be treated in court, right? Now, I also would like to get a figure. When it's 85%, how many actual numbers would that be? That represent?
Based on the figures provided by LSA, we have 1,799 matters that were referred from the LSA between January 2017 and April 2022. So 85% of that figure would have been the ones that we were unable to process through the courts. We would have still served quick notices to the unknown occupants at that time. Our office, our patrol staff and inspectors of state land and our land enforcement officers would have been actively trying to assist in obtaining identification information so that we can process some of those through the courts. 85% of that 1,799 figure would be 1,500 matters that we were unable to process immediately. We have also engaged multi-agency task force and also trying to find identification information for these persons.
So some of the delays may be a delay in your patrol staff doing their duties.
Yeah, yes, we do have We do have an issue with staffing, and if the commissioner may provide some figures in that regard. Okay, so our staffing is a serious problem. Literally, when the Divestment Act currently in 1975 Limited came into effect, we got 75,000 acres of land approximately. Our staffing was, prior to that, the patrol staff was 80. At this point in time, we have 28. By cabinet minute, we, just 1 second, 1532 of 2014, we had a land enforcement officers unit created. We are supposed to have 36 LEO ones, land enforcement officer ones. We have at this point in time 14. We're supposed to have 3 LEO tools. Their contract has expired and 2 of them are now on short term. They had the monitoring and enforcement coordinator is also on short term. We're supposed to have 2 BOA 1s and 1 BOA 2. We have none of them. That staffing is by OJTs. So given the shortfall in the staffing, it is really taking a toll on us. Additionally, the legal officers, prior to this, we had 9 attorneys. To date, and that was 2015. In 2019, we got 3 legal officers, 1 legal officer 2, and 2 ones, whose contract is about to end and who we are basically now awaiting whether they're going to be on short term or the contract is going to be. So staffing is a major issue in managing spotting in state lands.
Okay, so I understand what you're saying. Staffing is a problem, but who is responsible for staff in your departments?
The Permanent Secretary, Ministry of Agriculture.
Good. So we will direct a question after to that. But what I would like to know, though, is that you mentioned that the patrol officers, right through you have that staffing problem, 3 legal officers in the land management division. So how could those officers go to court with all these matters? But I have a newspaper clipping here that I want to use where increased land grabbing during pandemic, where it was mentioned in that article, more than 200 cases involving the state and illegal land occupiers were dismissed last year alone because of a lack of legal representation on the part of the state. So there may be a failure of the state to provide the legal staff to proceed with this. So I think this is a shortcoming that definitely the Permanent Secretary may need to address because it was mentioned publicly and now again mentioned here in this meeting today. But I also, before I put that question to the Permanent Secretary, I want to know how are you dealing with even your own patrolmen who are easily induced? Because I noticed there was an article recently where Ministry of Agriculture employee charged with forgery. That's a member of your it was I think one of those patrolmen, and there were 3 reports in the newspapers recently. I think one was in the Guardian mentioning one Robert Mohammed. It was 64 days ago. Yeah, so there are other matters that were mentioned where another agriculture ministry employee charged, and about 3 of them within the last few months. I want to know, have you dealt or put any security measures in place to screen your patrol? I mean, that may be from the Ministry of Agriculture to screen those personnel and to any other measures, because I think it was mentioned one of those individuals had paperwork with a stamp and a seal and a signature of the Commissioner of State Lands. So do you have any anti-fraud measures in place to deal with this? Because this is not just lack of staff, but if your staff are turning a blind eye, taking inducements, if they are not bringing the forthcoming information forward, your legal officers would be at wit's end to manage. So could you mention if there are any sort of anti-fraud measures in place?
Yes. So I have written to the PS asking for the change of the stamp and the seal. I have written to PS concerning members list
of staffing, some of whom we have asked to be removed from the building, at least from the division and transferred. The stamp and seal basically was done by a member of staff of patrol. We have also written on behalf of the patrol staff, because the patrol staff is in range 9, which is approximately $5,000 per month. They are given a traveling of $500. Now, in this day and age, $500 traveling is not making sense if they have to patrol or visit areas. So literally in my request to PS, I have said we need to relook the posts, we need to upgrade the posts so that persons are not easily induced in taking funds from members of the public. Additionally, the officers that go out in the field, given the job requirements, they are out there, it's dangerous and all of that. We have written to the PS asking for some improvements in their wages, in their in getting uniforms and getting proper IDs for them, all of this. So we are waiting on PS request answer to the request.
Well, I thank you for your seeking the interest of your staff under you, your patrolmen and your staff, and better pay, etc. As you see, the need for even gas prices have gone up, petrol have gone up. But have you? It was mentioned that sometimes these people go in the dead of the night and they put structures up, and once they are occupied, it now takes a different scenario. What about asking for staff to work on weekends, overtime, to have staff coming out at night to look? Do you have any sort of request for getting that overtime to? Because I think we are missing that weekend gap where people could put up a structure.
Yes, we did ask for the for overtime or for the staff to work outside the normal working hours. However, as public servants, it basically means they would have to go back to the union, back to CPO. So that may take a little while. Outside of that, we have been liaising with the multi-agency task force of the TTPS that assists us with illegal mining and with spotting. They are there. We have asked that the TTPS give us a unit so that they basically, with the commissioner's deadlines, and can manage these things. Our problem with the multi-agency task force with TTPS is that they don't just work with the commissioner's deadlines. They have other areas which they go to. So when they switch, or if they're doing something else, we tend to have to wait until they have time for us.
So I remember there was, in 1990, there was a vibrant anti-squatting unit. So I think your recommendation is via the TTPS that we get a unit, a special team, back again. Is it that one of your recommendations?
Yes, it is.
Okay. Yeah. And yeah, so I think member Lachmidial has a question.
Yes, Chair, a couple out of everything that was said. I wanted to find out specifically if in writing we could get, since the last report, which I think was 2017 to now, based on the number of reports from LSA, how many notices were served by Commissioner of State Lands, how many matters filed, how many persons have been evicted. You made a statement that the court usually rules in favor of the squatter. I'd be interested to find out why that is so, whether cases are being dismissed for lack of representation or if there's an actual finding of the court that persons are entitled to squat, because I find that to be a bit concerning. So if we could get some information on that, about the squatters being there. Could you specifically then as well identify how many cases have been filed in relation to Caroni lands? Because you mentioned that with the divestment of Caroni, the remit of the Commissioner of State Lands has increased significantly. And I would like to know, for example, how many instances of squatting, and let me declare my interest. I do have an interest, as Ms. Citran would know, and perhaps recall representing people who are entitled to carrying lands and who cannot get access to their lands now because there are persons illegally squatting on the lands, and it falls to the Commissioner of State Lands to now give the former workers of Carrying 1975 Limited what they are entitled to, and which to date, some 20 years later, they cannot get because of squatting by persons. So I would like to know how many parcels of Carney land have been reported with squatters, and how many of those persons have been served with notices and court matters filed specifically for Carney lands, because I'm concerned about Carney land and land grabbing on Carney lands as well, which are, belong to the workers on the DPCF program.
We will provide you that in writing.
Mr. Chairman. Mr. Chairman.
Yes, Mr. Ford, you can go proceed.
Based on the request by the Honorable Senator there, is there any sub judice matter with regards to what she just asked? Just need some clarity.
No, there's not.
Judge and jury, Madam Senator?
No matter has been filed, but I've had interactions with the Commissioner of State Lands based on the matter, and I don't think that it's a issue for whether or how many notices have been served with respect to it, but I have sent some correspondence to the Commissioner of State Lands. There's no court matter. Sub judice relates to a matter which is before the courts.
Okay, well, I just wanted to be sure that we...
Sure, no problem.
Member Amin, you could proceed.
Thank you, Mr. Chairman. Mr. Chairman, I have a concern about how LSA selects the areas that they are going to regularize. And I ask that with regard to settlements that are named in the Act where persons' regularization is pending. I noticed that recently we have had very little in terms of containment, and I recognize both LSA and the Commissioner of State Lands Office indicating their restrictions in terms of staffing. I have seen newspaper articles with persons receiving certificates of comfort in numerous areas, and I am a member of Parliament, and I have within the constituency of St. Augustine areas named in the Act since the original Act in 1998, and that Act was revised in 2013. But these settlements, we still have outstanding certificates of comfort to be presented. And we run into issues where public health is concerned because the Tunapuna Piako Corporation is restricted in terms of how it can go in and put in drains, for instance, even roads, water, running water. WASA is refusing to put water mains for persons to have pipe-borne water, which is such a basic thing for any citizen. I have residents who have been living for more than 20 years on the lands, and they cannot get a letter from, they cannot get a TNTEC approval because of a directive not to give squatters electricity. And I find it untenable for these basic utilities to be denied where people are entitled to certificates of comfort in a space that is in the Act, in the schedule, as a designated site to be regularized. And I question the LSA's priority, whether it is political. I know that there's a party in government and they have political priorities in marginal seats and so on. But I am concerned for the basic amenities for running water, lights, and public health where drainage and garbage collection is concerned. And I'm asking the LSA, what prevents you or what makes you decide on your priority where regularization can take place and to allow citizens to access these basic amenities?
Chairman, I will attempt to answer.
Sure.
Okay, so the basis of selecting sites for regularization, and regularization is a twofold thing. One is regularization in terms of tenure and processing of tenure. There's no basis really for like you see, like it's in fact all applications are being processed as we speak. As I pointed out before, we are very close to concluding our investigations on all applications made to the LSA in terms of regularization of tenure. Regulation of tenure deals with certificates of comfort in the first instance, followed by statutory lease and deeds of lease. With respect to infrastructure development, how sites are selected is based on socioeconomic data that the LSA has at its disposal. It's based on social surveys conducted by the LSA, information available from our 2009 to 2012 comprehensive survey that was done, information available from our 2019 social survey exercise that took up the living conditions of individuals in all 251 sites. So on that basis, the decision is made on how we select sites for regularization. We have done sites all over the country, regularized sites, and putting infrastructure all over the country. In fact, our numbers show that we have regularized more than, in full-scale regularization, we have done more than 29 sites. We have done at least 20 sites in early and emergency works. And as we speak, we have at least 15 sites where we're doing pre-construction works, including areas in St. Augustine. For example, Dukesing Street, where we have done an outline plan and submitted that document to the Town and Country Department for approval. But there are challenges in many of these areas as we speak with respect to regularization because of the haphazard way people have settled, because of some of the low-lying areas that we have to deal with. So there are challenges when you come to the statutory approvals and moving forward with regularization in some of these areas. And we, of course, seek the necessary approval from the Town and Country, the Drainage Department in particular, where there are a lot of challenges before we can actually do physical works. So that basically is how we approach regularization and development works in these areas. With respect to water and electricity, the LSA has no power over water and electricity, and the provision of same, the relevant pieces of legislation that TNTEC is governed under and Water and Sewerage Authority, they have powers within the LSA to grant water and electricity to persons in these areas. In fact, no permission is really required from the LSA as far as that is concerned. Once you live within a certain distance of an electrical pole, I think it's 50 feet or thereabout, I stand to be corrected, you're entitled to an electricity connection. There's a similar clause within the Water and Sewerage Authority Act where they can connect persons for these facilities. So that's outside of the remit of the LSA.
So you mentioned, yeah. Ms. Morris Julian, I think you had a question. No. Oh, Ms. Amin, you could continue.
Thank you, Chair. Two things. Where persons have applied for electricity and water connection, the agency often asks if you don't have a letter, a certificate of comfort, they often ask for a permission letter from LSA. And this also happens when persons are applying for minor repair grants from the National Self-Help Commission, had victims of natural affairs and so the non-issuance of a certificate of comfort public utilities. So I would like the CEO to take note of that. And secondly, I want to ask if the LSA has, in terms of working with representatives, because we do have a line minister for the LSA, we do have members of parliament, and we do have a political party that is in power that have their own representatives. And I have been finding that even when I, as a legitimate member of parliament write to the LSA. I receive acknowledgement letters, but I find that the person who was the candidate for the government who lost the election seems to be getting response, seems to be getting grants from the government to do houses, starter houses, which require the permission of LSA.
Chairman, I must object with the way
Yes.
line of this
No,
question is
no,
going,
you can't
Chairman.
object to my question and my
Chairman.
constituency that I represent. So, Mr. Chairman, if I may continue.
Mr. Chairman, I am asking through you, Chairman, respectfully, that Mr. Amin is bringing things here without evidence, without proof, and we have to follow and ask the questions in a certain manner.
So, Mr. Chairman, if I may continue.
Ms. Ami, no,
yes.
At this stage, I think you brought up the questions there. And it was, you know, I don't know if there could be any response quickly from any response we can get there from the member.
But Mr. If you'd allow me to complete my question, it has to do with LSA giving permission for grants to allow persons who currently occupy to do repairs on their homes, particularly in case of disaster victims, as well as to construct starter homes, because the LSA and other agencies have the programs where they allow the construction of starter homes in squatter developments. And I see starter homes being constructed in Western constituency. It is on a political directive, no problem, because I do understand some of government. But my concern comes in where the work is done only on a political directive, not in collaboration with the elected representatives, the legitimately elected representatives who have been making representation. And I speak specifically for St. Augustine constituency. And as I say, Mr. Chair, I have no problem with any person, political or not, who makes representation on behalf of people. My concern is where have done in a haphazard manner that appear to be solely political to the exclusion of
Thank you, Ms. Amin. But to the point you're making is there may be some sort of control into the giving of these grants and starter homes, probably politically motivated. So let us say now that is out there, the perception is out there. How do we respond? I want to get a response from the LSA in terms of fairness, transparency, in terms of control. You know, give us a take on this, because you, just to respond quickly, what manner you have there that, you know, the perception outside wouldn't be that persons might be using, you know, your agency starter homes for voter padding, or remember in these times, because, so you have to give us that idea quickly in terms of what do you have in place to show us that this allegation, you know, you're going to address it.
Chairman, can I respond, please? Just for the record. I'd like to put on the record that the LSA does not select squatter sites for improvement based on any political intervention, any political directive, or based on any political issues. It is done purely on the data collected for when our social services department go out into these communities and collect data. And in particular for the St. Augustine area, we have been making interventions inside there. We have also completed some starter homes in the St. Augustine area. And I will ask the CEO who has details on that to present further information to the panel now. CEO?
Chairman, with respect to the selection of beneficiaries for the Housing and Village Improvement Program that the member referred to, where we provide starter homes to members of the public, It's based, as my chairman indicated, on purely socioeconomic data and data that we have collected from our social surveys and from limited CSO data that we have available to us on living conditions of persons in areas all over Trinidad. In fact, we have done starter homes in many other areas. We've done in Mbakide, San Fernando, we've done in Toco, Maracas, Komoto, Labrie, Matura, Calparo, Caparu, Claxon Bay, Chabonas, Diego Martin. It's all over Trinidad. There's a strict criteria for determining how a beneficiary is selected, and the two most basic things is number one, income. Your income has to be $7,000 and less per month, and that's the family income. So that's how someone will qualify. And of course, the home has to be in a dilapidated condition for us to intervene. And those are the two most basic criteria which is used in determining beneficiaries for this program. In terms of again, for other utilities, as I pointed out before, if you're within a designated site, a site that is listed in the Act 25 of 1998, the authorities, the several different agencies will approach the LSA just to confirm whether the person is a legitimate applicant, and the LSA responds appropriately with respect to that.
Yes, thank you. Ms. Morris-Julian, you could proceed.
Thank you very much, Chairman. Chairman, through you, and this is directed to the LSA. I have several questions, but let me start with, through you, Chairman, to the CU. I noticed what you said about the data collection, right? I just want to understand the inadequate data. Why is it inadequate? How, besides the pandemic? Because I don't understand how you were able to say there was a reduction during the pandemic. Please clarify for me, if there was a reduced reduction, how did you then collect the data?
Okay. Member, with respect to data collection, and based on the information that we have provided, the LSA has, in our view, have done a great job in terms of data collection. Even during the pandemic, of course, there were limited patrols during that particular period of lockdown, but we have been collecting data, and we continue to collect data and provide that information. We have provided these statistics as we have it with respect to data collection for the period 2018 to 2022 to the committee. And we continue to collect data and provide. So really, we think we are on the button with respect to data collection and the provision of data to the Commission of State Lands and the information that we have been provided. As indicated before, we have sent information over the last 430 years to the Commissioner, indicating that 1,170 new structures constructed on state lands, on designated sites that we are required to patrol. If any restriction at all is that we restrict ourselves to sites listed in Act 25 of 1998 with respect to data collection and submission of information to the Commissioner of State Lands.
Okay, I understand now. Thank you very much. Through you, Chairman, it was stated to date 538 beneficiaries have been allocated lots in 9 sites under the program. I'm speaking specifically about the government-aided self-help housing program. I was really happy to hear a member said that they have HVIP in their area, because just a plug here, Chairman, I don't have any in W. Amera yet. Knock on wood. So first, what challenges have hindered the allocation of the remaining lots under this program? And secondly, how many applicants have commenced the actual construction phase and have completed their construction on this program?
Okay, Chairman, members, so there are 2 different questions here. One with respect to the government-aided self-help housing program, where we are processing applications and persons who have applied under that program. In total, 700 names there was a random draw where 700 names were drawn through a computerized process. And there have been recommendations coming out of the Ministry of Housing and Urban Development. To date, 553 letters of office has been issued to persons who are now at varying stages of being processed, all in an effort to get a deed of lease at the end of the day from the Commissioner of State Lands Office. Persons are at the stage of the Commissioner of State Lands, they're at the stage of the Chief State Solicitor's Office for preparation of deed. There are a number of persons whose sale agreements have been executed and sent to varying financial institutions for their processing of their mortgages. In fact, I think what we have now is approximately 375 persons at that stage. So people at different stages. In terms of construction, persons have not yet begun to construct because they are seeking the necessary approvals. Apart from getting the deeds in their name, they then seek the necessary building permits and approvals from the various agencies. Town and country, getting WASA clearance, etc. People are going through those stages. What we do anticipate before the end of this year, we should see a number of these persons starting to build because they would have received the requisite approval from Town and Country and from the requisite statutory agencies to start construction of homes. And we look forward to that. Just to note that the LSA is also providing technical advice, house plans at no cost to beneficiaries under this program. So the persons who, once they get their deeds, etc., approach the LSA, we provide these facilities to them. They can then take one of our plans, etc., go to the Town and Country, go to the different approval agencies to get their approvals. So we're doing all of that as we speak. So we expect to see a large number of persons starting to build within this calendar year. With respect to HVIP, I think you did mention and raise the issue of HVIP. And as mentioned before, we have, unfortunately, we may not have done any in your particular areas yet, but it's based on social survey data that the LSA has. It's purely social survey data. We have collected information in various parts of the country, and it's based on a point system in terms of the condition of the villages. It starts at the village level first. So we looked at villages where you have in dilapidated conditions, neglected villages, and then we go into those villages, we apply the scoring system, and we decide which of the persons can benefit on the program. As I said before, and I'll reiterate, $7,000 and less in family income, and the house must be in a dilapidated condition for us to intervene. Of course, there's a repair part of the program as well, where we do repairs to certain homes. Again, you have to qualify under the program.
Okay, good. Thank you very much. Through you, Chairman, the reason why I asked too is because I have a very large squatting area in Carapo. And recently I visited the area and my parliamentary colleague, Minister Gonzalez, over the water situations that we have there. So I'm wondering, how closely does LSA work with Town and Country, WASA, TNTech? Because I can tell you that the water situation is really terrible. There were numerous illegal connections, and we will all know the history of Carapo and why Carapo got to the stage that it got to. But I am really concerned. How do we move forward? Is there a meeting? Do you all interact? Meaning all the WASA, TNTech, LSC, State Land Commission. Is there a monthly meeting? Is there some way to move forward? Because people are continuing to go and build, create their own roads, little or no drainage, and then of course they expect that someone will fix it.
Chairman, member, Carapo or race course, as we have it listed, has been a challenge for the LSA. Members will recall that that site was developed during the period 2010, 2011, around that time. At the very onset, we had Town and Country approval for 703 lots in that particular area. Because of the haphazard way people have settled and the rush for lands that took place in the years after the development, we had almost 450 vacant lots on that site. And there was a huge rush, and people settled in a very haphazard manner and continue to do so, moving around their boundaries, etc. on this site. and has created no end of trouble for the LSA in terms of the development. As I said before, we had 703 lots earmarked based on town and country approval. When we were finished, we were only able to get 530 lots in the site because people settled in their own way. These 530 lots were approved by the director of surveys, and yet still over the last few years, people continue to move around and shift their boundaries, etc., posing no end of trouble to the LSA in moving the regularization process forward. And that has been a challenge. You asked if we collaborate with the other agencies. Yes, and as our permanent secretary outlined at the very start of our presentation, we have, since 2020, we have an approvals coordinating committee. And just last month, we had a meeting of the approvals coordinating committee where we under our minister who chaired that meeting last month, we were able to pull together all the approval agencies, including WASA, TNTech, Drainage Department, Town and Country. We were able to get all of them in a room, a representative, and we have now re-established that committee where we are meeting monthly and working out the issues on the various sites that we have. So issues like what you have in racecourse, etc., will certainly be addressed at these meetings. But we do have issues inside of that particular area racecourse where people have connected. We have put in a water connection for each lot that was there, but because how people have moved around and doing their own thing inside, it was no enough problem. So what we are presently doing and what we will have to do for areas like racecourse, and not only racecourse, Bonaire, racecourse, Pine Settlement, Kangali, etc. Although we have surveyed and have the approvals for all these sites, we will now have to resurvey because how people are moving around on these sites. So part of our community development work and try to come out and meet the communities and explain to them the difficulties that they pose when these things happen is what we're trying to do as well. So we can educate people about moving around and moving their boundaries, etc. But we will be working with the approvals committee and working with the residents to try to regularize the situation that we have inside there.
Sure, Chairman. I would just like to state there is an entire new community that recently moved there in Carapo, and I can tell you that we are all very well aware of all the criminal elements in Carapo, but for the most part, Carapo has good law-abiding citizens, and they are very upset with the current state. So I'm hoping that the LSA will pay particular attention to the land grabbers and the continued squat lords that are in Carapo and see what we can do. Your submission, through you, Chairman, also stated that further allocations will be made to persons who qualified under the approved criteria under the HIVIP program. You already stated for us what is the criteria under $7,000. But what is the time frame that has been established for the completion of the allocation process? And if possible, what additional areas and locations have been earmarked for future allocations? We will accept it in a written form, Chairman. I mean, I would love to know if W. Murray is there, but I can wait.
Yeah. Certainly, we will provide further information in writing on what is required.
Okay, Chairman, through you, I have one last question.
Sure.
All right. In the submission, it was stated that the dedicated resources for government institutions responsible for assisting with the processing of title documents is necessary in the successful execution of the government's self-aided program. How has the LSA engaged the Office of the Attorney General and the Ministry of Legal Affairs? Is it with a view to ensure that dedicated support is given regarding the issuance of title deeds?
Okay. Chairman, members.
Go ahead.
Okay, so yes, we are dependent, the LSA is dependent on these various institutions, including the Chief Solicitor's Department, which comes under the Office of the Attorney General, for processing of title documents. In fact, the process is that the LSA submits to the Commissioner of State Lands, and the Commissioner of State Lands sends instructions to the Chief Solicitor's Office for the preparation of title documents, deeds of lease, etc. These documents were then, when processed, would then be sent back to the commissioner and to the various mortgage institutions for the finalization of title documents to persons. There are challenges, as we are all aware, at these offices with respect to we strongly suspect with respect to human resources. And again, it's out of our remit, but those challenges has to be addressed if we are to process these documents in a much faster way.
Thank you very much. And that actually was the second part of my question, the challenges. So through you, Chairman, if possible, if we could get a list of the challenges submitted to us, and we'll take it from there. Thank you very much, Chairman. Appreciate it.
Thank you. Good. I would like to find out about regarding the national squatter containment policy. In the submission, it was stated that recommendations of the agency has already been submitted to the Ministry of Agriculture, Land and Fisheries, and a draft cabinet note prepared to the Ministry of Agriculture. What is the status of the national squatter containment policy?
The Chair, the Office of the Attorney General sent the draft amendments on the squatter containment policy, and it was reviewed by the Commissioner of State Lands Office, and within 3 months, our contribution was made towards those amendments, and it was sent back to the Office of the Attorney General, and according to the Cabinet minute, it was for the Attorney General to take, the Office of the Attorney General to take to the Legislation Review Committee to review the amendments. That is because we are that our last thing on that was sent in January of 2020.
So it's really held back at the AG's office, I think the Law Review Commission. Okay, all right. You stated that land grabbing by squatters is a significant hindrance to the execution of this program. Is the LSA of the view that the length of time taken to allocate these lots have contributed to the settlement of squatters on lots?
Chairman, yes, to an extent. The longer you take to allocate, is the more risk that is involved in terms of being open and persons grabbing lands. So yes, we need to have this process done in a much faster way, where when lands are developed and that allocation process needs to be speeded up. And as I pointed out before, you have various agencies that are involved, Commissioner of State Land, Chief Solicitor's Office, you have the mortgage institution, TTMF, etc. You have the approval agencies. So it's a group of institutions that need to look at the processes and the way of speeding up the allocation process. What the LSA has put forward is, and in accordance with our Act 25 of 1998, is to declare sites where we have developed lands and have lands available as land settlement areas. And this will give the power to the LSC, where the LSC's chairman will be allowed to sign leases, rather than having to go through some of the bureaucracies that we have to go through at this time. That matter is also before the CPC as we speak. So we think that there should be some traction on this, and that should be going forward very soon to the Parliament to declare sites as land settlement areas, at least developed sites. And in that way, we can be able to process a lot of these title documents in-house rather than having to go to other arms of the state.
Have any MOUs been considered?
With respect to the various agencies, there's no MOUs has been considered. It's really the relationship that has been formed between the various agencies and working with the various agencies over the years.
Your submission stated that the Land Settlement Agency collaborated with the Ministry of Planning and Development on their guidelines for regularization of informal settlements on state lands. Have these guidelines been finalized?
No, Chairman, the guidelines have not been finalized, but it's an area of concern that the LSA has and the Ministry of Planning has. And this deals in particular to hillside developments in and around Port of Spain and environs, where it's estimated that we have over 20,000 families who are squatting. And the guidelines have been developed. We have contributed towards the guidelines to the Town and Country Planning Department. As far as we know, it's not yet been finalized, but something that needs to be done, where we need to work out appropriate standards for these particular areas. It's not going to be the same as regularizing other areas of the country where people have settled. In these particular areas, people have settled in a much tighter way. There's very limited space between structures, and the guidelines have to be reviewed and approved for us to move forward with regularization in these areas. This is the reason that why the LSA has only been doing what we call early and emergency works in a number of these areas, in the hillsides of Port Spain and environments all the way to Diego Martin, because the appropriate regulations are not in place for us to deal with full-scale regularization. But as we speak, I know Town and Country is working on the finalization of these guidelines.
So in terms of like forested areas, I mean, do you have any sort of the conservative forests, any sort of liaison with them to, if you see certain things happening, that they may have the power to go in and stop any degradation of our forested areas?
Yes, Chairman. We have been constantly reporting issues. Most of the reports in most instances, and in all instances, will go through the Commissioner of State Lands, who has direct contact with these various other agencies. But we do report areas of concern, especially in forested areas, etc.
In terms of your submissions, you stated that 13 vehicles are assigned for patrolling your sites. Are all 13 vehicles in service?
Yes,
okay.
These vehicles are available, and from time to time you do have breakdowns, so we are constantly repairing and having vehicles ready for patrols.
Sure. And your submission stated that the LSA utilizes the services of private security firms to engage in patrols and monitoring of sites classified as hotspots. What is the total annual cost of hiring the services of these private security firms?
Okay, so over the years, we can provide that in writing as well, but the patrols, we do use private security firms for patrolling hotspot areas, especially developed sites, in order to protect those lots. And the primary reason for using the private security firms, because they are able to work 24 hours and they can patrol and monitor the activities that happen on these sites. With respect to the actual annual cost, we can provide it in writing to you.
So you don't have a general figure, aggregate figure, annual figure?
In terms of the per site, it will cost about $50,000 per site per month. So let's over the years over $600,000 in terms of the patrolling a particular site.
Could you confirm the names of the security companies that are currently contracted by the LSA?
We'll provide it in writing to you, Chairman.
And could you tell me how many drones you have currently in use?
The LSA has 2 drones that we have purchased. And as I pointed out very early, this has been providing really good support for the LSA in terms of monitoring activities on sites. Not only for the containment activities, this has provided information for the development of sites where these drones, they are linked to the actual data on the ground and to GIS points. So that has been provided really good information for the LSA. So we have 2 drones at this time.
Your security firm, do they work on weekend? Because I think we have gotten a deficiency in the state. We are stating that there's the public servants who may have to come out and inspect and patrol. In your areas, the security, do they work on weekends to see if there's any rush to put up housing on that period?
The answer to that is yes, Chairman, and that's the reason for the private security firms, because they are able to work on the weekends and monitor the activities, what is happening.
And do you give that information to the Commissioner of State Lands?
All of that information is, once any illegal activity is uncovered, it's supplied to the Commissioner of State Lands.
Sure, thank you. Member Ford, I think you had some questions.
Thank you, Mr. Chairman. To the Ministry of Housing and Urban Development, P.S. Davis-Williams. Yes, P.S. Davis-Williams. In your presentation under financial allocations for the government-aided self-help program, I would like to know what factors account for the increase in the revised allocations for the government-aided self-help program, which we know was formerly the Land for the Landless program, over the periods 2019 to 2020, 2020 and 2021, and we can include what's happening for 2022 if you have that information. Madam PS.
Yes, member. Over the years, the LSA would have highlighted a number of issues, particularly increase in material, the increase in the number of persons who will have applied for this facility, the challenges with regard to infrastructure development. And because of that, the justifications were submitted to the ministry, and we would have made the necessary representation in order to increase the allocations.
Okay. As a follow-up also, now we would have known the Land for the Landless also had an aspect with regards to land only, whereby, you know, at one time I know the Ministry of Housing were looking at the possibility of persons who could not have qualified for housing could be probably given land at a reduced cost and so on. Is there anything in the system with regards to that in going forward, 2022?
Chairman, we do not have that as a specific program, but I could provide that in writing. But I could provide that in writing if I do the research and let you know.
Okay. Okay. All right. And one last question with regards to Mr. CEO at LSA, Mr. Hussein.
Yes,
again, Tunapuna would have benefited with regards to those low-income houses, right? I know one of the concerns that we had in the Tunapuna constituency was with regards to the land ownership, whereby, you know, some individuals, you know, they could not have provided, you know, that support documents. But again, having land tenure stewardship being on the land for long periods, you know, like individuals having receipts or some sort of documentation. Again, I know that we are all governed by policies and guidelines, but I know I have a series of individuals, you know, families that, you know, looking forward, you know, would have qualified with all the other qualifications necessary, but not that particular aspect. You know, so again, in going forward, you know, if your board, you know, could look at, you know, some sort of adjustment, because again, these are people that the member of parliament, the councillors and so on in our area would have identified, you know, that could qualify for these particular benefits. So it's something in going forward that I will appreciate, you know, if we could look into, please, Mr. Chairman. CEO or the chairman of LSE.
Member, if I'm permitted, Chairman, if I'm permitted to answer, there are serious issues with respect to persons who, as the member pointed out, qualify in terms of the income criteria, qualify in terms of their house being dilapidated, but because they are unable to provide land tenure documents, we are unable to intervene, because they could be competing interests from many different persons from the same piece of land, and not because somebody has settled on a piece of land, it's theirs. And the last thing we would want to do is to construct a home and then construct a home for a particular individual, and you have another individual coming and claiming that house at the end of the day. So we have to be very careful, and the member would appreciate that the LSA is just being very cautious and careful in that before we use the state fund to do any sort of intervention like this, that we have to ensure that the person is the legitimate owner of that piece of property. If he's renting, he must get permission from the landowner in writing. He must have a statutory declaration done as well. If he's on state land, we must have proof for how long that person has been there. He has a certificate of comfort, etc. So we try to make sure that we do all these things, dot the I's, cross the T's, to make sure that, you know, we are not challenged at the end of the day.
I am guided, Mr. CEO. Thanks, Mr. Chairman.
Chairman, I have a question.
Sure, you could go ahead.
Thank you. Coming off of that, the question about the what is now called the government-aided self-help housing program, formerly called Land for Landless. I wanted to find out about the selection process. I believe that prior to 2015, it was a random draw. I think that there's now a weighted, some sort of a weighted type of system, as well as persons, the minister with responsibility, I think, for the Ministry of Housing would make recommendations. Could you tell us how many persons received lots of land under this program from 2015 to now? How many would have been on the recommendation of the minister, and how many via the other system? And I have a couple of questions with respect to the development of lots, of areas for this Land for Landless, well, now whatever it's called, formerly Land for Landless program. What are the areas designated? How many have been developed? And who are the contractors that are presently contracted to develop those sites?
Okay, so Chairman, I'll attempt to answer as much as I can here. In terms of the Land for the Landless program, question was asked with respect to that. That program was closed in the 2017, if I recall correctly. 418 persons who qualified under that program to move forward. Out of that 418 persons, just about 50% of those persons have agreed to move forward and to get their mortgages, trying to get their mortgages, etc., processed so that they can benefit from the leases under the program. With respect to the government-aided self-help housing program, which replaced the Land for the Landless program, to this date, we had one public draw. So it was done by a public draw where 700 persons' names were drawn based on a points criteria. And those persons are being processed as we speak. There are recommendations that has been put forward, and there's a criteria under the program where there's a 70% for draw and a 30% under the recommendation that comes from the minister responsible for the program. So that's how it's decided who moves forward on it. We can provide information in writing with respect to contractors, etc. That has been requested.
Yeah, and how many sites are presently under development, and who are the contractors? Just
Certainly
a follow-up. Yeah, you said 30%. You said 700 persons at the random draw. I just want to be clear. Is it that the 30% of the people who are recommended go into the draw together with those who qualify on your weighted system, or is it that the persons who are drawn randomly, that 700, come from the 70% and that the 30% are automatically, given a certain allocation?
So the 700 was drawn. There was a total of 1,000 lots that was available at that time for distribution. So 700 was drawn, that's 70%, and then the 30% comes from recommendation. But just to note that the persons who come through recommendations have to follow the same strict screening process and criteria. They have to be landless. So we have to prove that they are landless. So in-depth searches are done for names to make sure that they are landless. They still have to fall within the income category as determined by the program. So they still have to meet all the criteria, basic criteria for the program to move forward under the program. So, they still have to meet the, also if I may, they still have to go to a mortgage institution and qualify to pay for the lot of land. And just to note that the prices agreed under the program is 30% of the open market value for a lot of land. So all persons, whether they're drawn or whether they come under recommendations, still have to meet that criteria.
So then the only difference is that the 30% who are given, they don't have to take a chance of being part of the draw. They just get a recommendation and they go through.
Well, but still have to meet all the criteria.
Yeah, sure. They landless and they have to get a mortgage and all that, but they don't have to take the chance. They are selected out of the lot of everyone who applies.
Yes.
Good. Okay. And
this is very similar. This is very similar. It was very similar to what existed with the Land for the Landless policy. Similar criteria.
Good. And you'll provide the information on the contractors and the areas for development?
Certainly.
And just also, not just currently under development, but if you also have plans for areas that would be developed presently, like for projections, if you could provide that as well.
We do have a number of areas that we're doing pre-construction works, so we can provide that information as well.
Good. Thank you very much. And the contractors.
Certainly.
Thank you.
You said, given the expanded role of the agency, the board of the LSA has recommended to the ministry the establishment of a special projects unit within the agency to develop and execute works outside of its core responsibilities, categorized as special projects. Now, I understand now you are in the process of dealing with the Petrotrin land distribution. How, in terms of that, how far have you reached in that land distribution?
Okay, and so in terms of the Petrotrin project, where the LSA's the responsibility lies with the development of plots for former Petrotrin workers, we have started works in a number of sites. The most advanced of those is the La Savane and Nursery site in Guayaguari, where based on the lots that are available in these two sites, we have done a draw for 70 persons out of the total number of persons who applied under the program. The total number of applicants was just over 2,800. From that, we did in-depth searches to find out which ones were landless, and it's just about 50% of those persons are landless. We did a draw for the first 70, and those persons, there was a recent selection of lots that was done for a number of those persons out of the 70 after we made all our checks to make sure that the persons were indeed landless, etc. So we've reached that far with this particular program. As we speak, we have another site that is being developed. That is the Glenroy Site in Princestown, which is expected to yield around 150 lots when complete. That development is in 3 phases. We have 3 different contractors on that site. One has actually reached close to 85%. The other 2 are just around over 50%. And this development is expected to be completed by, I would think, about the end of June, July, and then we'll seek all the necessary statutory approvals. So that site is another site that will be available for former Petrotrin workers. We are in the planning stage and pre-construction stage for a number of other sites, which we are working on at this time. We are seeking the necessary approvals. We're going through tendering processes, etc., so that we can make these lots available for the former Petrotrin workers who qualify.
So do you have the special projects unit in place already? See them all there, so is it something you are hoping to establish?
We are hoping to establish that. At this time, we're using the staff at the LSA, the technical staff that we have at the Infrastructure Development Unit to supervise and to manage these programs.
So the special projects unit will be an additional staff which could expedite your function then?
Exactly, and that special projects unit is expected to also expedite the function and under our responsibility under the Youth Agricultural Homestead Program as well, where we are expected to assist with the development of plots, agricultural plots under that program, and to construct starter homes using the model of the Housing and Village Improvement Program. So yes, this special projects unit will aid the LSA in carrying out our mandate under these programs.
So there's a lot under your portfolio now, but how many positions will be established to support the work of this unit?
We've put forward a proposal that is around 20 persons, I think. I can provide that in writing as well, the proposal.
And what is the estimated additional recurrent expenditure that will be incurred with the establishment of this unit?
It's around $3 million.
Have you have a time frame set up for the establishment of this unit?
So our board has given preliminary approval. We are now seeking the necessary approval from our parent ministry to take this forward.
Yeah. Okay, sure. Member Ford, you had a question?
Chairman, well, I just wanted to come back in by notice that Senator Sagram Singh Suklal has a hand up before I put back up my hand. So could I give way to the Honorable Senator and then I could come back in because I noticed her hand was up before I just raise my hand. I'll come in after if possible.
Okay, sure. Member Suklal, you can proceed.
Chair, I honestly didn't realize I had my hands up, but that being said, I know that I'm batting very, very low in the lineup here. Chair, I apologize for my late entrance into this meeting. Of course, I was dabbling in the a PAEC meeting as well. But that being said, I know a lot of the areas of concern for me was already addressed by previous members of the committee. One of the things that I'm just, which I don't think was, and you could correct me if I'm wrong, Chair, is as it relates to the interagency collaboration. In the Ministry of Housing submission, that in the LSA submission, mention about this interagency collaboration, particularly between the LSA, the Commissioner of State Lands, and Municipal Corporation was mentioned. My concern is just not a concern really, but rather a question relative to that committee. If I can just find out a little more about the objectives in particular of this particular committee, this interagency committee that has been created. I'm not sure who would be in a position to answer it. I know it's from the LSA submissions. It's from the LSA submissions.
Chair, if I may.
Sure, proceed.
Okay, so the interagency committee, that's one of the recommendations that came out of the proposal with respect to containment legislation, and then out of the recommendations out of this very set committee when we appeared last. It's really the purpose of setting up the committee is for collaboration among the various agencies who are required to monitor and enforce on state lands. The agency so far, the different organizations who have come together, it's the Commissioner of State Lands, the Land Settlement Agency. We now have an arm of the police service, the interagency task force that is part of this committee. They are all part of this committee, and the sole objective is for sharing of information and to take the necessary action in the fastest possible time to deter squatting, new squatters.
Has the committee actually convened, and could you give me a little information, perhaps, if you all have indeed met, what is currently before this said committee as it relates to the matters you just identified?
Okay, so yes,
sorry. Why I'm asking this is because, I mean, to my mind, even before asking the question, I had an idea this is what the committee would entail. And of course, in dealing with the issue of squatting, it is critical that you have that interagency task force, for want of a better word, created. And that sharing of information is critical if we are to really treat with the issues that LSA is charged with. So I had that in my, I just wanted it to be said for the record, at least for the record, so, you know,
sure.
At least that you all understand the importance of said committee. Now, just back to the question. You were going to answer relative to what if the committee has indeed met, and perhaps give a little information or insight into what is currently before the committee.
Okay, Commissioner of State Lands might be in a better position to, as chair of this, to answer this, but the committee has been meeting on a regular basis, and the matters before the committee would be current matters reported, new squatting reported. Of concern would be areas of hotspot that has been discussed, and possible action and using what particular laws we can use to deal with the particular situation. And as members would have pointed out, there are many concerns, especially in the eastern part of the country, in Valencia, etc. We recently had an area of concern in Antigua Road where 25 acres of forestry land was cleared, and that has been one of the matters before the attention of the committee, and along with the new squatting in Valencia, Pine Settlement, the Babwande area. As mentioned during this meeting as well, areas of concern would have been discussed would be like where the new highway is proposed and the squatting activities are taking place there and the action that could possibly be taken.
Okay. One last question, Chair, because as I said, I know most of the other areas were covered. Thank you very much for that information, CEO. In the submissions from the LSA as well, at paragraph, I think it's the additional submissions, question 7. No, there was actually a statement. You stated in your response that the LSA last wrote to the Permanent Secretary of the Office of the Attorney General in 2017 regarding an update on the progress of the committee's recommendation. And then you went on to say that the Land Settlement Agency did not receive any further instructions from AGLA as it relates to directions and instructions. I have personally been trying to locate this particular correspondence. If Chair, of course, through you, if I can make a request that, because I'm particularly concerned that, no directions or instructions have since been received, right? Chair, through you, if I can make a request for a copy of that correspondence. So at least on my end, I can do whatever necessary inquiries for us to be able to see why since 2017, a response has not been forthcoming to the LSA. And that if Chair, if I can make that request, I will be grateful. And perhaps I can be able to lend some assistance in whichever way I can, just to ensure that the information is forthcoming so the work of the people of Trinidad and Tobago can be done and completed. Chair, those are just the extent of the questions that I have. Chair, I also want to thank you. I know in my absence, certain things would have transpired. That's over and done with, but thank you for chairing the meeting in the manner in which it ought to be chaired. Thank you, Chairman.
Thank you, Member. I think Member Ford had a question also. And members, we'll be wrapping up at 12:45.
One last question. This is directed to the Commissioner of State Land, Mr. Chairman. Again, we can get a little synopsis of it now, because I think we can be able to identify clearly what the answer to the question is, but I'd also like it to be submitted, Mr. Chairman and Secretariat, in writing. It's to the Commissioner of State Land. Who or what agency is responsible for the application process leading to the approval for state lands for the purposes of acquisition for a recreational ground or space for a particular community? Right? So if a particular community would like to get a piece of state land for recreational ground or space, who or what ministry, department, municipality in the particular area is responsible to communicate with leading up to the process? Because I know it will have to eventually go to cabinet. Can I get a little feedback? But I'd also like it in writing, please, Mr. Chairman. Thank you.
So any acquisition of state lands comes through the Commission of State Lands. Given that this is a recreational facilities you're asking for, normally we would ask that it pass through local government, because somebody needs to be maintaining the ground and all of that. Depending on the area where it's located, once it's identified, the request is made to your relevant ministry, to the relevant ministry, local government, who will then do a note to cabinet and then send it forward. You can also send it to us, telling us where the area is, if it's available before you do anything, so that we can do a title search and make sure that this area that you are asking for is in fact available. If it's acquisition, it means that it would be private lands that you want to acquire for public purpose. The process is that we would have to find the owners, identify the area.
Excuse me, Madam Commissioner, no, it's state land, right? It has already been identified, one. Two, it's in the Maracas-Kono area. We have identified the cadastral drawing from Lands and Surveys, but I just need to be clear as to who it is that be addressed to in order to start the process of this particular application. So as you said, so I can write to you, I can write to the Commissioner of State Land, we can copy local government, and we could probably copy your line minister and probably the Tunapuna Piako Regional Corporation chairman to start the process, I presume.
Mr. Chairman.
Sure, Ms.
I might be able to provide some guidance for Member Ford. As a former chairman of Tunapuna Piako Corporation, the process that I am aware of is that the regional corporation will make the representation. So the MP or the residents can make the request to the corporation, and then the corporation will seek to have the land transferred from either Commissioner of State Lands or LSA. And yes, a cabinet note is required, and that then becomes part of the vesting order that has a listing of all the properties vested in the corporation. So the corporation as the legal entity that will now have this parcel of land vested in it is the one to make the request for the transfer of the title. So the chairman of the Tunapuna Piako Corporation has to be engaged, and a resolution of the council is required, and the councillor can make that request in council, or the MP can make that request in writing to the chairman, and it will go to the council.
All right, but still, Mr. Chairman, I would like, coming out of the meeting, to get an official response from the Commissioner of State Land Office, please, Mr. Chairman.
Yes, so thank you for that interaction that we got from Ms. Amin, and I'm hoping we can get the a response also. As we about to close, I wanted to ask two things. I realize there's difficulty for the, to get staff to patrol and whatnot. So I think we would have to write to the Permanent Secretary in Agriculture to, see how best we can help with that situation. But I wanted to ask something. The difficulty is really like on a weekend. Commissioner of State Lands, I would like to ask, if someone definitely builds a house, I could understand there's the difficulty. But if you now see loads of material being put down, like the galvanized and the wood and etc., is there a way that you could just go and remove that before persons could actually construct a house?
Well, technically, if we see material on state land, we would have to go and inquire who put it there and why. The problem is most times when we go to inquire who, we do not get a name. Most people either don't want to tell us, or sometimes we even get persons telling us the wrong name. So that when we go and serve the notice, the persons look at us and go, yeah, that's not my name, that's not me. So we have issues not only in patrolling over the weekend, we have issues in getting the correct name, the person, who is the person that we need to serve the notice to.
But can't you just confiscate this material? It's on state lands. I mean, if you have some liaison with the Ministry of Works who have material, you can just say, come in, take it and give that material to somebody else. To me, it's a simple fixed situation. The material is there before they build. That's one. Second thing is, have you ever considered, recently Parliament, we have passed the Trespass Act, right? We've amended the trespass legislation. I mean, is there a rule for the trespass legislation? Somebody's now trespassing on state land that, you have a different entity, or somehow police could go in and charge them for being on this property, because I think the trespass legislation was amended to include a fine of $50,000 and a jail term for 10 years. So what's your opinion of that?
If I may, Chair, one of the discussions that we were having with the interagency task force, which, as we would have discussed earlier, comprises of the Commissioner of State Lands Office, the LASCSA, and the multi-agency task force of the police service, Transvaal Police Service. That was one of the discussions that we had. We did write to the Solicitor General in 2021, asking for a legal opinion on whether or not the Trespass Act can be used. We would have had discussions with the legal officers at the Trinidad and Tobago Police Service, and while we were both of the opinion that Trespass Act can be used to evict squatters on lands, on both state lands and lands that are currently under the purview of the LSA, the Trinidad and Tobago Police Service legal team did not want to pursue the matters without this legal opinion from the Solicitor General. So that is the only thing outstanding, and we are ready to test one of those matters before the courts.
Yes, so we are looking for some exciting times and some other avenues you can help. So at this stage, would any of my members want to ask any other questions at the end? We are now about to finish. So if there's no further questions, I would like to get some brief closing comments from Mrs. Claire Davison-Williams, the Permanent Secretary, Ministry of Housing and Urban Development.
Thank you, Chairman. I just want to extend our thanks from the level of the ministry for the comments shared by your committee here with us today. We remain committed to assisting the LSA in improving their mandate, and we are certainly ready to continue working with them and working with the state lands, the Commissioner of State Lands, in order to further the work of the LSA. So thank you, and we're willing to continue to provide the support and the monitoring role that's required of us.
Thank you. Would Mr. Wayne, and his Chairman of Land and Settlement Agency, give closing comments?
Thank you, Chair, and members of your team. And thank you, members of the Ministry of Housing and Urban Development and members of the Ministry of Agriculture, Commissioner of State Lands, and members of the LSA. I thought this morning's session was informative. Lots of issues came up, and we have dealt with them. There are issues, serious issues involving the expansion of squatting and the eviction of squatters. And I think some more work has to be done between the agencies to put that to rest. Very often you have structures being erected overnight and limited resources available to contain them. So we have some work to do in those areas. Other than that, I think this session was very informative, and we continue to do the work of the LSA as best as we could. Thank you, Chairman.
Thank you. Would Ms. Banmati Sitcharan please give us some closing remarks?
I would like to say thank you, Chair. Thank you, members, for this opportunity to share with you all. To PS Housing Chairman and CEO of LSA, and by extension, all members of staff, thank you very much. In closing, I would like to say that squatting does not occur only on LSA sites. So given the fact that LSA, the National Squatting Containment Unit is put up, I would like to say that it is not only on LSA sites. And in Justice Golden words, it may be, and I'll quote from her, it may be that all is necessary is for the Commissioner's office to be provided with the proper infrastructure, personnel, and resources, and to be equipped with the machinery necessary to efficiently manage, monitor, and prevent illegal squatting. Thank you all. Good afternoon.
Thank you. So we realized together we would have to look at the unregulated proliferation of illegal squatting. We have to realize, even though there's a humanitarian aspect that we would be looking into, and the agencies would be, monitoring and helping that, we have to realize that we have to look at the consequences of the environment for health, overburdening the infrastructure and social order. So therefore, a balance needs to be struck. And I think we all together could work for this. And our recommendation will definitely be trying to get this achieved, to be this whole idea of unregulated squatting and satisfaction of those who are there for years to be somehow tweaked in a better manner. So when we put in this report, hopefully next time we are having another joint select committee, we'll be in a better position. So I'd like to thank officials of the Land Settlement Agency, the Ministry of Housing and Urban Development, Ministry of Agriculture, Land and Fisheries for your contributions in today's proceedings. I'd like to thank my committee members who participated remotely and the staff of the Office of the Parliament for their procedural and logistic support and the viewing and listening audience. At this stage, I'd like to declare this meeting adjourned. Thank you.
Thank you.